The Minister, Dr. Sri Peter Chin, have said that they are not in a position to disclose because these contracts involve private parties. We, Parti Keadilan Rakyat, have made a decision that if the government does not disclose these contracts by next week, we will file an application in court to require the government to disclose these contracts. This is because public interest prevails over the commercial interests of the parties. These IPPs have come about because of the government decision to produce power by way of an IPP. So the power of the government to enter into this contract is derived from the people. The government is the trustee and the servant of the people. Today, the people are asked to pay a higher electricity tariff. So the people are entitled to know what is the reason why the government entered into a very sweetheart deal for the IPPs. Because the government is supposed to protect the people, not to protect the IPPs. So why were IPPs entered into, as a result of which TNB has to pay 16 cents per kilowatt when TNB's own cost is only 8 cents? Why did we enter into IPPs, as a result of which there is now a 40% excess capacity? That means TNB does not require this electricity, but TNB has to pay a capacity charge to these IPPs for producing something that is not required. Under this supply agreement, gas from Petronas, which production cost is between 15 to 16 ringgit per British million thermal unit, is sold to the IPP at 6 ringgit and 40 cents. In 2008, it was increased to 10 ringgit. Today, another 3 ringgit 13. But under this new concept of pass-through, this increased cost now is passed through the IPP, TNB, and the consumers, the Malaysian rakyat, now have to pay for this cost. So the public is entitled to know why they are paying for this extra cost. And if there is a sweetheart deal, then we will have to go after the sweetheart, because it is a very bitter pill for the public to swallow. This is a public interest litigation. This has been done before. A similar application has been made with regard to the agreements for the privatization of the water distribution. And the toll concessions, the agreements have already been declassified. The water agreements, the High Court agreed that because of public interest, it should be released. But again, the government, in their normal habit of not providing information, appealed and got an order for the stay. The whole world has changed to greater transparency. There is freedom of information, and normally this kind of information is provided without having to go to court. So we have enough legal precedence to ensure that the court does help the people to obtain information on these contracts.